It's Thursday, and therefore it's Justice Thursdays. So we have these conversations every week as much as we can. We want to have a conversation looking at justice and accessing justice. Social transformation through access to justice. That is the strategy by Chief Justice Martha Koome, and we look at, okay, so she said this. We have to keep track of this and remind her and the entire judiciary that yes, we want to we expect greater access to justice. We're now joined by the Honorable Justice Dr. Freda Mugambi of the High Court to have this justice conversation. We are going to have a different one of a kind. We'll be talking about greening judiciaries in Africa. Green. Last week, we had a conversation about going green, and we had Dr. Green in the studio, Dr. Isaac Kalua Green joining us. Today, we have Dr. Mugambi in the studio talking about green, but greening judiciaries. We want to understand what that is all about. Good morning.
Morning to you.
Welcome to Kenya's biggest conversation.
Thank you very much. Thanks.
Your ladyship, may it please you, this is the hot seat.
Please, we agree. Do not put me on a hot seat.
That's why we're starting this way, Your Ladyship. May it please you, Your Ladyship. That is the hot seat of the Situation Room. We'll be much obliged to pin you to a corner.
All right.
And make you respond. But don't worry, it's going to be an easy ride. For example, CT will start by giving you a very simple, straightforward proverb. You listen to it, and then you'll give us your own interpretation of this, Judge.
Am I on cross-examination?
Oh, yes.
Okay.
No.
Try me.
No. Eric has spoken an untruth. When you have a guest in African tradition, you do not put them on the spot. You welcome them, you make them feel at ease, and you begin a conversation. So let's begin our conversation.
Especially the first day, mgeni siku ya kwanza.
Yes, mgeni siku ya kwanza. Ya pili ni nyingine, lakini huyu mgeni si siku yake ya kwanza.
Asante.
Yes. Our proverbs for the whole of this week, which are, in our terms, are weekends on Friday, from the country of DRC. What is said over the dead lion's body cannot be said when he is alive. In this country, all lions are male. What is said over
There's another country where lions are female.
Yes, they are called lionesses.
And there are no lionesses in Kenya. All right. Oh, it's DRC. Okay.
What is said over the dead lion's body cannot be said when he is alive.
Judge, this is from the DRC. When you hear it, what do you get from it? What do you think the Congolese were saying?
What is said when a lion is dead can be said, but when it is alive, it cannot be said.
No, the other way around. When it is dead, you can say anything.
You can say anything.
Anything.
Exactly.
When it's alive, you can't say it.
Yeah.
Dare you.
Yes.
Should I say anything more? Like, when the lion is alive, dare you. I think I have answered the question. Dare you. And I think we see it every time around us that, dare you say it while I am looking at you, while I am watching. But when I am 6 feet under, we are all very quick to say the things that we ought to have said and we could not say when that lion was alive.
So should we continue with that, or should we start saying things when the lion is alive? So the lion knows what we truly, honestly believe and think about the lion.
While he is still alive, because he will not hear it when he's down under there. Yes.
All right. Judge, you are a judge of the High Court. Are you based in Nairobi? Just give us an introduction to the Honorable Justice Dr. Freda Mugambi.
Okay. My name is, as you have stated it, I serve at the High Court Commercial and Tax Division. But perhaps what is even relevant for this conversation is that before I joined the bench, which is not a very long time ago, I had worked with the judiciary. I'm not new to the judiciary. I was at the Kenya Judiciary Academy. I know you have hosted Justice Dr. Smokin Wanjala on this program.
Yeah.
I have been his deputy for the last 6 years. And so by virtue of that position, I have been a member of the board of the discussion that we are going to be having today. And yes, so that is me.
Okay.
Yes.
There's a regional symposium that's coming up, and it'll be on greening judiciaries in Africa. What does that mean?
Let me start from the beginning.
Yes.
This was 2017. Discussions around jurisprudence on environmental law. What are judiciaries doing? Are judges knowledgeable in the area of environmental law? And a lot of the research that went into that actually told us that there was no training at the time of judges on this topic. It is a very, one of those topics that you don't even cover in law school unless you decide to pick the elective. And so that is when this conversation began. How do we move towards enhancing green justice? How do we move towards ensuring that judges and judicial officers have the knowledge to even adjudicate over environmental issues? How do we exchange information amongst judges within the region? The environment has no boundaries. It's the same environment for everybody. It's the same issues, whether it is in Africa, whether it's Kenya, Morocco, Uganda. And so the conversation around greening judiciaries and having a continuous conversation then began in 2017. 2018, first judicial colloquium and culminated to the Johannesburg Plan of Action. All the African countries that were there, and I represented Kenya in 2018, agreed to the Johannesburg Plan of Action. That included establishing a structure through which we would ensure that there was sustainability of judicial education and environmental law matters. And then we moved into 2019, Maputo, Mozambique, second regional symposium. More African countries had bought into the idea. And we established, it was in 2018 while in Johannesburg, where we established the Africa Judicial Education Network on Environmental Law, AJNL. And now we are in Nairobi 2023. AJNL is now of age, and we are now getting into the substance of why the network was established.
Taking stock of what has been done since then.
Not just taking stock, but now saying AJNL is of age. So a lot of the conversations around 2017, 2018 have been around strategy, putting together structures, what is going to happen. But now we chose as Kenya to discuss the topic of climate change.
Okay.
So we are now getting into the substance. And we said, let us begin those conversations from the third regional symposium.
Judge, what are the highlights of this Johannesburg Plan of Action?
While in Johannesburg, the 15 or so participating African countries agreed to develop training material on environmental law. And I'm happy to say that Kenya spearheaded that particular dialogue. You may know that Kenya is the only African country with a specialized environment and land court. And for that reason, we were way ahead in terms of preparing our training materials. So that was one of the highlights, the development of a framework of training manuals and training curriculums and reference tools, which were then interpreted into Portuguese and French. And which have since been adopted by all participating countries to ensure that there's continuous dialogue on environmental law by judges. It was also, the other highlight was, of course, the formation of AJNL and the establishment of the first board, proper caretaker board. And the agreement that within the next 2 years, every African country participating would have to show what they have done in order to build capacity amongst judges and judicial officers in the field of environmental law. Yeah.
So if you were to break it down for us in terms of how then this comes to life in individual countries, because I mean, yes, you did mention Kenya does have an environmental and land court. So the assumption is that, well, okay, so we've got this covered, right? So what's the issue? But what does it mean then now when we're saying that we're really greening the judiciary? If there's a specialized court already in existence, what kind of cases are we talking about? What, in terms of the practice of these establishments from Maputo to Johannesburg to Nairobi, what does it then mean in practicality that we see then coming out to play?
Let me start with Kenya, where we are. The Constitution, for the first time, speaks about the right to a clean and healthy environment. Break it down into smaller bits. We have the issue of climate change, which has been recognized as one of the planetary crises in the region. And it is not by chance that we chose to speak about climate change. We now have a Climate Change Act in Kenya, and we are talking about cases coming to court about pollution, about how to access that clean and healthy environment. But then we are saying, are judges ready? Do they understand the dynamics behind the clean and healthy environment? And then it goes down to this access to a clean and healthy environment, and what does it mean to even the marginalized communities? So when we talk about climate change, we are talking about these very different weather patterns, which eventually then affect the resources, access to resources, which then affect marginalized communities, which then affect also, there's also a gender dimension to it. And all of these are discussions that are going to form part of the two-day conversation. The human rights issues, what is the emerging jurisprudence, not just in Africa, but globally, how have other countries tackled, public interest litigation cases? And so while we are doing this to be able to share the jurisprudence that has come from the Environment and Land Court, we also hope to tap from other countries what issues they have actually faced and how the judges have dealt with those particular cases.
Would they only play out then in the Environment and Land Court, or will we see that then all of this has an opportunity to play out across the board where anything is adjudicated over?
No, the reason I talk about the Environment and Land Court is because of the very specialized jurisdiction that the Environment and Land Court has. But you see, environment matters are also human rights matters.
Yeah.
So that could play out even in the Constitutional and Human Rights Division. But of course, knowing that the Environment and Land Court can also determine petitions that come to it in the form of Environment and Land Court matters. There could also be commercial disputes attached to it, because pollution is also an issue of how much money putting in to clean the environment. So really, it's a diverse situation that we are talking about.
When you look at the court system, the judicial system, and I look at other courts that have been in existence for a long time, say like the courts that deal with criminal matters, the courts are dealing with a subject that is understood by the citizenry, meaning we have a fairly clear idea of what a crime is. We have a fairly clear idea of what is good and what is bad. And so when matters are brought to court, this isn't something that is new to the experience of the citizens. Now, subjects around the environment are not new to the citizens, but when we now talk about matters that then would end up in a court of law, but which are in the space that we refer to as the environment, land, that we also understand. Now, how then is this bridged? There is what the law states about this particular subject. There's what one would like to see as being done. There are agencies as well as ministries in this country that are mandated with the task of looking after the environment, looking after land. And then there is the citizenry who interact with these realities. Are we in tandem really? You have a court process that manages these matters. You have a citizenry who interact with these matters, which at some point, the interaction, the understanding, or the lack of it thereof, brings about a situation that it has to come to court. How are we balancing this?
Let me say this, that the primary role of the judicial system and the courts, which comes at the very end of a dispute, when all has failed between the parties, is to interpret the law and to adjudicate over the dispute. And true, I agree with what you're saying, that a lot of times there is a disconnect between the judiciary and the bench and what other bodies that are involved in actually implementing the law and ensuring that that we have a clean, healthy environment, and that all the policy issues and all the regulations are followed. And this has actually been identified as one of the issues that require conversation. We have in one of the panels a session on the interaction between the judiciary and stakeholders on not environmental law, but we are themed on climate change. And part of the issues that I would anticipate would come out here is that connection between the judiciary, the executive, the legislature, in terms of even court orders, following court orders. When the court makes a certain order, are those orders enforced? Are they implemented? Resourcing the judiciary. How does the executive, legislature, and the judiciary relate in those terms? There is also the aspect, again, you talk about whether the public is well aware of the disputes, but you know that where judges sit, judges do not ask for cases to come to them. Judges have to wait for cases to come to them. And so it has been said, and it is true, that a lot of the cases that go before the Environment and Land Court are mainly on land. 95%. And so the conversation, we have LSK invited to the symposium. There's a conversation then around why is it that advocates are not coming out with whether it's public interest litigation, and we have a lot of civil society organizations also invited. And the idea is to understand what are the dynamics, what are the challenges, why aren't we getting a lot more cases on environmental law? Because I know there have been a few, the Nairobi River pollution case, for instance, but we want to have more because the framework is there. So that disconnect is widened by the fact that where judges sit, judges have to wait for these disputes to come before them.
As a layperson, it's a yes and no situation in this sense. When a judge makes a pronouncement, what exactly has happened when it comes to the law of the country? A contribution has been made.
That is correct.
And from a lay perspective, we now have something that you, legal minds, refer to as precedents.
That is correct.
Now, every time an issue comes to court and it presents something that probably previously had not existed or something that needs to be looked at in great detail, I am saying that the bench, the judges, the magistrates have within them that power that already is nestled in the law to be able to contribute to that which didn't exist. Either by way of a question, this became apparent to me in 2017. I had heard about it, but it was obvious to me when I looked at what the Supreme Court said in terms of now what a layman would refer to as suggestions. This needs to be done, this needs to be looked into, this needs to be looked into. I mean, it hadn't been looked into, but now it became something that could be actioned. Now, with the reference to some of the things that we don't seem to have, and the bodies that partner with the judiciary in ensuring that these matters that relate to the environment specifically are understood before they even adhered to, your pronouncements become very important because they shine a light in an area that there was darkness, but it also tells you a path that could be followed. What are your thoughts?
I agree with you. But then, judicial pronouncements are not made in vacuum.
Precisely.
And while there is an opportunity, and a great opportunity at that, for pronouncements and precedents to be set on matters environmental law, I think those cannot just come in vacuum. And so what we are saying is, let us have more issues brought to the fore that then also give the judge an opportunity to be able to make suggestions, even for legal reform. And that is done all the time. But what I'm saying is that from the quarters where these disputes should be brought to the fore so that the conversation can even begin. You see, if a land matter comes before a judge and the land matter is, say, about inheritance, there is no opportunity for the judge to then begin talking about,
how many trees do you have on that?
Exactly. Have you planted trees on that land?
And if the trees are on that compound and the trees are part of the dispute, sure.
But I think what I can say is that so part of what we hope to achieve with the third regional symposium, if you even glance at the discussions that we will be having about the role of judiciaries in enhancing. Remember, yes, it's on environmental law, but we've taken a specific theme. Everything is centered around issues climate change. So impacts of climate change in Africa. We are talking about the role of judiciaries in enhancing climate justice in Africa.
Yeah.
We are talking about climate change, human rights, access to justice. So basically, the whole idea is to build capacity. We are talking about emerging jurisprudence on climate change, adjudication globally, not just within the region. We'll be speaking about gender perspectives and in climate change adjudication, and also the issue that you have raised, interaction between the judiciary and other stakeholders, and how, particularly in the field of climate change.
Climate change.
Yeah.
Let's take that break. We've been having climate change conversations, and we are still having another climate change conversation now, looking at how to get climate justice. And we have the Honorable Justice Dr. Freda Mugambi with us in the studio, talking about what the judiciary is doing in Kenya and other judiciaries in Africa to talk about greening judiciaries. A third regional symposium coming up. Article 42 of the Constitution talks about the environment. Every person has a right to a clean and healthy environment, which includes the right to have the environment protected for the benefit of present and future generations, and to have obligations relating to the environment, all of them fulfilled. We also have Article 43, economic and social rights, which also touch on environment and clean and sanitary places to live in. So let's continue this conversation after the break.
This is the Situation Room, the only way to start your day.
Conversation continues with the Honorable Justice Dr. Freda Mugambi of the High Court of Kenya, who, like you've told us, Judge, before you joined the bench, you had spent like 12 years of your career dedicating that to building the capacity of judicial officers and going up to the point of being the assistant director at the Judiciary Academy. And now, when you went to South Africa and you met with the other officers from 15 countries, among the things that was discussed then was the establishment of AJNEL, the Africa Judicial Education Network, which is also looking at building the capacity. One of the things that you started by pointing out to us was the realization of the gaps, knowledge and skill gap, in matters of environment and climate change. And that's why even you have been discussing, okay, how can we enhance this knowledge? How can we enhance this skill of judicial officers? But let's then step outside of that. What are you doing to build the capacity of lawyers on this? We know, of course, in Kenya, there is the Council of Legal Education. There is the Commission for University Education. is there any conversation that's taking place on making sure that then we are also, as we build the capacity of judicial officers, we are also building capacity of lawyers?
Yes. So, first of all, when you say that I've been in judicial training for 12 years, you're giving me many extra years.
Are you? Is that so?
That was around 7 years at the Kenya Judiciary Academy.
Okay.
Well, that said, Article 172 1D talks about the continuous capacity development for judges. But the other key role of the Judiciary Training Academy is also to enhance dialogue amongst stakeholders. And the Law Society of Kenya lawyers are part of our key stakeholders. So when we hold sessions for judges and judicial officers, we take the opportunity to also invite a few lawyers in the space of the particular subject that we are talking about. And that is not, environmental law issues is no exception. So when we train judges, judicial officers, we have stakeholders present. We speak with NEMA, we speak to advocates involved in litigation around environmental law issues. And in this symposium as well, the Law Society of Kenya is invited. And that is part of the dialogue. And not just the Law Society of Kenya, other stakeholders as well have mentioned NEMA amongst others.
You're not mentioning the Council for Legal Education.
It's interesting that you should speak about the Council for Legal Education because I came from the council before I joined the judiciary. Now, the Council of Legal Education is the regulator for legal education in this country. So I believe that the kind of engagement that we'll be talking about is with the Kenya School of Law. And there are ongoing conversations and around building also training programs with the Kenya School of Law. We have had engagements with the academia and how it is that the universities can also, be part of judicial dialogues during capacity building. So yes, there is a lot of work going on around that perspective. Yes.
Admiral, and looking at then what we hope to achieve, what would be the markers to say that now this establishment then has succeeded? What would be the markers that you put in place to say, okay, once we've done this, then we can see that this overall picture, then we start to see it being entrenched or embedded? What would we see in practice that you would then say has made this successful?
Output to me would be the jurisprudence, progressive jurisprudence, more litigation around environmental law issues. But I have to also say that we have come a long way since 2017. In 2017, the conversation was around do you even have training programs on environmental law? So if you're talking about outputs, that for me would be one key output that indeed shows that we are on the right path. So at that time, we have no training program on environmental law. We don't even know how such training is done. That is one. Two, exchange of information. If you look at the symposium, the Nairobi Symposium program, you will find a rich menu of experts on the subject from Kenya, from the region, and even globally. So that exchange of information. Third, exchange of jurisprudence, resources. When we started, we were just trying to, even figure out how would this happen. Now, one of the highlights of the Nairobi Symposium is that the network will be unveiling its website. And on that website, one of the key things that you find is resources, jurisprudence from Africa. It's also networked to other global institutions on environmental law. So easy access to resources. So these are all, to me, winning points that I see.
As you talk about jurisprudence, like you said earlier, jurisprudence would be a result of a matter that has been brought before a judicial officer. Now, what do you do to catalyze those matters, to increase the matters that come before the judicial officers, so that then they find these judicial officers who have the capacity, who have a better understanding and knowledge on how to handle these matters? Because like you said, the question has been, even in the Environment and Land Court, it's more cases about land disputes, not on environmental disputes. So what is it that you look at as a strategy to catalyze more cases being brought before court touching on climate and environment?
Well, I know, and I'm going to put this for the record. I said that I'm not an environment and land court judge, and so my views would be my views, and not speaking for the court. But what I would say is that one of the key issues is capacity building, dialogue, interaction, such as what we are doing now with the symposium, teasing out the issues. And so while not all the lawyers will be able to attend the symposium, the same will be streamed live. So lawyers interested in environmental law issues will be able to stream in and pick out the issues that are being teased out by the experts, by judges, even by the Law Society, and by other participating delegates. And, that then brings to the fore, oh, you mean these are the issues, these are, prospective litigation points, and then the cases can come to court, and then the courts can be able to give us progressive jurisprudence. So it's all about dialogue and capacity building.
I see a multiplicity of players in this.
Yes.
From at community level, those social justice networks.
Exactly.
Human rights advocates, the Kenya National Commission on Human Rights, and civil society. Because like you said, it's not just about people going to the Environment and Lands Court. You can also go to the Constitutional Court and demand the fulfillment of your constitutional rights.
Yes.
You can look at it from various angles. Maybe some disputes that go into the criminal court could have an element of climate and the impact of climate change that actually has led to those criminal disputes. So how do you engage all of them beyond this symposium, so that there is more awareness of these things that we are seeing? Like Mangari Maathai had said earlier, one of the biggest wars that could be fought in the future will be because of climate change and environment. How can you create more awareness so that people can then see matters as they are?
I agree with you, first of all, about the issue that environmental matters have a tendency to be cross-cutting. There could be civil disputes, there could be criminal disputes, there could be commercial disputes, it could be a human rights issue, it could also be an environmental issue, it could be a family issue, and many other areas. And so I believe that one of the key strategies then is to not just limit it within the environment and land court kind of disputes, but to bring out all the other aspects of environmental law as we continue dialoguing in all of the different spaces, whether we are speaking, when we stop to speak with the Environment and Land Court judges and we get into a commercial conversation, is to have those continuing dialogues even in other spaces, and to also encourage, I believe, the key players in other sectors, and to just continue with the dialogue even beyond the Environment and Land Court discussion. And as I said, we are also really counting on the media to help us spread the message. And we had a media briefing yesterday just to explain what this symposium is all about, and to ask them to be with us throughout the symposium to make sure that we are also giving daily briefs to the public on what it is that the judiciary is talking about. Because I think a lot of times the climate change discussion has been about, say, the government, but we are saying that the judiciary also has a role to play, and we want you, the media, to speak to people out there and inform them what we are talking about in the symposium.
It's interesting that you mentioned that, because then we see this as people, communities, public, very involved in what happens at the climate level, at the environment level, but then also would it be the desire then that there's the realization of the public as well that they can then bring some of these issues to court, and that they can be sure that you will have judicial officers now who are ready to deal with this? We saw the mushrooming of many a Kenyan now going to the courts, realizing that they can actually go to the courts and have some of these issues settled. As relates to now climate change, as relates to climate action and environment, would it then be the hope that through this, more Kenyans, more communities, more people are aware that judicial officers are now also aware, and that they can be more comfortable bringing these issues before the courts?
Exactly. That is well put. I couldn't have put it any better. That it is important for the public to know that, this is no longer an academic question. I know there was a time when climate change was more of an academic question. And if you look again at the place of this discussion in the STARG blueprint, social transformation through access to justice, it is about the people. The environment affects the people. It affects the access to resources. It affects the vulnerable people in this society, the marginalized. And so what we are saying as a judiciary is that bring those disputes. We are having the discussion. We are having the dialogue. We are now more informed and more aware, and we are picking from other countries that have had similar disputes. So we will be able to listen to you, and we will be able to adjudicate over those disputes. But you have to bring them to us so that they can cease being just academic points. Yes.
In 2016, two very interesting things happened. Well, one relates to the continent, but one relates to Kenya. There was an oil spill off the coast of Mauritius, serious oil spill. Now, it brought to the fore this very, very discussion about environment. Then here in Kenya, a case was begun around that same time. It was later determined by the courts, and a whooping amount, it was a class action case of something like $12 million was awarded to residents of Owino Uhuru. The case of lead poisoning. Now, every time one hears of environmental cases in this country, you cannot hear the cases without thinking, but there's an agency that's supposed to deal with these environmental issues. NEMA. What's their role in it? Now, the question I'm thinking, and I'm going to ask it slowly and carefully so that what I'm saying does not sound incendiary. What role do the courts play in ensuring that the actions taken against a body such as NEMA that is found to be derelict of their duties? Because I'm thinking this in terms of how do people understand the importance of these things if the agency that's supposed to superintend it seems to go scot-free every time an issue that falls under their purview has occurred. And we hear of the issue, we know the consequences, but the agency just seems to go scot-free. And sometimes lives are lost. I'm using the word seems to. That's why I said I'm treading carefully here.
So your question is how the court
how do you punish them
ensures
more? That's what I'm asking.
The purpose of a court, as I said, is to adjudicate over matters brought to it, consider the facts, make a decision and a determination. But one of the ways that the court can ensure that its decisions are followed, and this is, of course, going by the jurisprudence from the Supreme Court and other courts on Article 20, that would be 23 of the Constitution, by use of interdicts, where as a court I say to you, go do A, B, C, D, come back to me after 90 days. And tell me what you have done.
Yep.
And I find that to be a useful tool. That without mentioning any agency names, I have found you guilty of ABCD. I need you to do ABCD to purge that wrong. Now come back to me with a report after 90 days and tell me where you are at and what you have done. And that is part of what happened in the previous case that you were referring to, where the Supreme Court did as such. So I feel that the Constitution gives the judiciary, a lot more leeway to be able to ensure that decisions that are made are not just academic pursuits, but that you can come back and report to the court what has been done.
You see, from a layman's perspective, it's the only perspective I have on this subject, really, is that this country seems to have understood the need to have agencies and departments that look after specialized interests and specialized issues. Again, I'm back on the NEMA case. It's just an example here. Now, what if the mandate that they have is not adequate? It's now an academic discussion.
Yeah.
If the mandate that they have to superintend this function that they've been given is inadequate and it needs to be expanded, and that requires a legal process or a process that ends up in some legal framing, how does one resolve this? Because if you already have a framework within which certain matters are supposed to be managed, but they don't seem to have sufficient muscle to actually carry out that mandate, what then do you do?
Legal reform. But I will say I'm not sure that I agree with you that the legal framework is the problem, that we do not have sufficient legal framework. I would tend to think that there is sufficient legal framework. The question would be why the default in ensuring that we are implementing the framework.
Okay. How do you measure this adequacy? When you say it's adequate, how do we determine its adequacy?
All the nuts and bolts and rivets.
Those ones.
Because I think also legal framework is an issue of interpretation, really. And I am not very conversant with the environment and management statutes, but I get the feeling that it is not really the legal framework that we are looking at. Because even when people go to court, if you look at most of the disputes would be around environmental impact assessment. So it is already provided for. The issue is, was it done? Was it properly done?
So it's a human resource inadequacy.
I wish not to speak for any agency, but I would just say that if I look, there's EIA provided for, then the question becomes, how was it done?
It conducted?
There's public participation provided for. Was it followed? Yes, no. And that is, to me, where a lot of the disputes arise. So I am not sure, really, I would agree that there is inadequacy of legal framework. But even if there were, then I believe that the institutions that we have are capable of pursuing legal reform agendas.
Can that be initiated by the court? For example, a matter is brought before a judicial office and you look at this and you see the mandate of this particular institution only reached this far. But if it had extended to maybe beyond point X to Y and Z, would be dealing with a different matter here. And so therefore you recommend legal reform.
With caution, I would use the word that you're using, recommend. Remember that the work of a judge is not to legislate from the bench, but suggestions for reform have been made in different instances. Yes.
I want to go back to the issue of lawyers. You have looked at the training of judicial officers. You have, under now Janelle, you've looked at developing training framework and material to build the capacity of the judicial officers. Do you feel confident that the lawyers are at the same level? Those that are being churned out of the various universities that go to the Kenya School of Law, are they at par with the judicial officers?
Well, different levels of capacity building there. One of the strategies that I believe have been adopted is to make environmental law a compulsory course at the university level. When I studied law those many years ago, environmental law was an elective course. I thought it was a very academic You know, I never thought, as I am sure many of my colleagues never thought, that this would be a very critical conversation. Who will even practice environmental law? Where will you practice? So I can confess to not having studied environmental law because it was not a compulsory course. So one of the ways of making sure that there is more awareness on environmental issues is to make environmental law a compulsory course. And I do know that it is a compulsory course now in most of the institutions, rather some of the institutions, so that when at least there's that foundation, then even when you leave university and you become a practicing advocate, there would then be more uptake of environmental law litigation. So that would be one critical strategy towards ensuring sustainability.
Okay.
Yes.
Coming to the conclusion of the conversation, 1 hour is a short time to have such an interesting conversation. But what are the dates for the third regional symposium on?
The third regional symposium will be opened by His Excellency the President of the Republic of Kenya on the 3rd of April. And will be officially closed by His Excellency, the Deputy President of the Republic of Kenya, on the 5th of April,
So
2023.
Friday.
Monday to Friday.
Where will it be?
It will be at the Safari Park Hotel. It will be a 3-in-1 conference. 3-in-1 conference in the sense that we will have the main plenary, with the main delegates. We have judges, we have environmental law experts, etc. And we will have the Chief Justice's Forum that also feeds into this. And then we will have the AGNL General Conference as well.
Okay.
Yeah.
Thank you very much for all the information. The Honorable Justice Dr. Freda Mugambi of the High Court of Kenya telling us today about the third regional symposium on greening judiciaries after work that's been done